Very good. I see Ms. McLemore and Mr. Anderson. We are ready, Ms. McLemore, when you are.
Thank you, Your Honor. May it please the court. My name is Deanne McLemore, and I represent the estate of Ella Fred Sweeney and State Farm Mutual Automobile Insurance Company. Your Honor, may I reserve 3 minutes for rebuttal?
Yes, I'll let you know when you get to that point.
Thank you. Excuse me. The issue in this case is actually one, for the most part, of first impression. And that issue is when deciding whether a plaintiff has recovered a judgment in an amount at least 25% greater than an offer under Section 768(7)(9, does the statutory phrase judgment obtain include prepayments by the plaintiff for future discovery that would accrue taxable cost if and when that discovery actually occurred? Now, our position on this is threefold. First, the statute doesn't especially provide for the inclusion of these prepayments. And the text of the statute must be construed strictly to favor the common law rule on attorney's fees. Second is Justice Periente's opinion in White v. Steak and Ale doesn't squarely address this question, but it's a question that needs an answer. And third, given that a defendant cannot know what future costs have already been prepaid in the days preceding a proposal for settlement, the statute can only provide a level playing field if it only includes the cost that a defendant can actually calculate when deciding whether to accept or reject a proposal. Achieving this means following the guidelines, the uniform guidelines on taxable cost. Very quickly, by way of background, plaintiff served my client, the estate, with a proposal for settlement, $30,000, March 21st, 2019. Plaintiff prepaid $2,375 in fees a few days before serving this proposal. We did not accept the proposal, went to a jury trial, and a judgment was ultimately entered for $33,823 and some change. So the trial court, when calculating the plaintiff, whether the plaintiff exceeded that fee triggering threshold, the necessary judgment obtained, the trial court included these prepaid fees in that judgment obtained, and plaintiff just barely exceeded the triggering fee threshold.
Ms.
Go ahead.
I think we're all familiar with the factual background of the case. I'm curious about one thing that I'm not certain you really addressed in the brief, and you've said today that this is a case of first impression, but isn't the general rule in Florida to disallow discovery deposition costs, the taxation of those, when they're not used in some way, in some way related to trial? And let me start with that. Is that still the general rule?
So under the uniform guidelines, costs that should be taxable, and that's the word, should be taxable, are, and I quote, a reasonable fee for deposition and or trial testimony of an expert witness. So our position in our briefs...
and let me interrupt with that, because I think there was a change in the analysis and in the rule to broaden the ability to recover costs for depositions, right?
Looking at the plain language of the actual uniform guidelines as they were promulgated by the Supreme Court active today, it says for expert witnesses what I quoted, that it's a reasonable fee for deposition and or trial testimony.
The case law seems to be that there needs to be actual testimony.
Yes, that is my point, Your Honor, and I'm sorry that if that wasn't clear. Testimony is required under the guidelines for a payment to be taxable, and that is our position. You can make a prepayment. That doesn't mean the payment is taxable yet.
Well, let me then take it to the next step. If there were evidence presented that the fees were non-refundable, is it your position that those would still not be taxable, even though they're the defendant's experts and the defendant chose experts who hypothetically have non-refundable fees?
Yes, Your Honor. I think that irrespective of the refundability issue, the primary issue is the guidelines have to be followed here. And that is actually the case of RJ Reynolds v. Lewis out of the Fifth in 2019. They addressed a similar issue on the guideline aspect, and it was regarding 4 expert witnesses that had not been deposed yet. And during the case, whether they had been deposed later or they were just non-testifying. And the Fifth said, no, you got to follow the guidelines. On the date the proposal was served is the date we're looking at. And if it is not an already taxable cost as of that date, it does not get included. And so our initial argument in the initial brief, and one we made in the reply brief as well, was that the guidelines have to be followed. And that's what we were talking about. That's what I talked about earlier with the level playing field. By the guidelines, the black and white law, the guidelines being followed, that allows everybody to know what the rules of the game are. They know what costs have happened already before that proposal is served. How are we to know what has been prepaid? It hasn't been taxable yet. It hasn't been considered taxable yet. And so that is why we think the linchpin here is that the depots hadn't occurred yet, and they didn't occur until well after. Now, the refundability argument is a secondary argument because these are defense experts. And so secondarily, not only were the guidelines say they're not taxable, but plaintiff would have got her money back. And she didn't prove otherwise. And she was the party with the burden of proof. Whether she beat her proposal, whether she was going to get her money back or not, was her burden to prove. So we presented evidence on, regardless of the guidelines, she would have got her money back on the date she served her proposal. But Judge Silverman, as you point out, we think the primary argument is you follow the guidelines. That's what the Fifth said in RJ Reynolds. I believe that's what the statute's saying too, because the statute itself says to follow the uniform guidelines as promulgated by the Supreme Court in 6B of the statute when looking at a plaintiff's proposal and whether it was triggered. That means that's what we need to look at here. And the trial court erred by not looking at that, by taking costs that became taxable later in the litigation and putting them into the judgment obtained. And these costs are what triggered the proposal, and that was error. Now, looking at the refundability issue as the secondary argument is we presented evidence that depots hadn't occurred yet, and these prepayments were both refundable. She was going to get her money back if this proposal on the date of the proposal.
But the documents that were filed with the court, am I recalling correctly, there were no objections to those documents?
No, Your Honor, there was no objections to
those. They were argued at the hearing?
Yes, they were. And I can point out the record site, we discussed the evidence on record site 1751 through 52. Our defense counsel said this is what we filed. These represent that they're refundable. So this wasn't something that was out of the blue. We filed this in advance. And actually the court in the order mentioned that we had this evidence. Albeit the trial court, we think, erroneously said it was limited because we are the only party that presented evidence. Now, plaintiff's argument in opposition, none of the arguments they made in their answer brief were ever uttered below. And so we would say that the court can't even consider those ambiguity arguments, not that they're viable, but can't even consider them because they fall outside the parameters of even a tipsy coachman rule. They're made up for the first time on appeal. But all they said below, plaintiff's only rebuttal was maybe these would have got refunded. Who knows? That was it. And that is on page record site 1758. So we presented our evidence that these would have been refundable. And there was no evidence to the contrary. And there was not even argument to the contrary. And so we feel the trial court erred in this regard by not holding plaintiff to her burden of proof in proving that she beat her proposal and proving her pre-offer taxable cost. So we think the judgment needs to be reversed because these should not have been included. If you take these costs out, the fee triggering threshold is just not met. And at the end of the day, we think that the court should write an opinion here. And I say that because this is actually a very important issue in the world of proposals for settlement.
If you prevail, you get an opinion, don't you?
That would be wonderful, Your Honor, and I agree.
But you're suggesting if we affirm, you would still like an opinion on it.
Whether you agree with me or not, and I would hope you agree with me because I feel that we have the law on our side, the black and white law on our side. But if you do not, whether you do or not, we'd actually write the opinion, because this actually isn't a very important issue in the world of PFSs. Because if this is the trial court's rule here is the rule moving forward, the game changes, because you're allowing prepayments of future discovery that hasn't occurred yet. And that is a really, really unpredictable rule that is going to be based on an expert witness's payment preferences instead of black and white law of the guidelines. And also this rule.
Let me ask one other question that just came to mind. Was there any evidence that in order to schedule the depositions, that I think there was something, at least for one of the experts, that it had to be prepaid by a certain date in order to get on his schedule? Am I remembering that correctly?
Yes, Your Honor. Dr. Rosenbach's fee invoice said that it had to be paid by March 21st, which is actually the date the proposal for settlement was served. Our argument is that doesn't matter at the end of the day. That fact, whether she had to pay that or not, isn't relevant to the argument, because it's not when the payment had to be made or when did the payment get made by plaintiff's choice. It was when did that payment become taxable under the guidelines. And further, the fact that it had to be paid on the date of the proposal still doesn't negate the fact that it would have still been refundable on that date, because it was refundable up until March 30th, which was 9 days after the proposal was served, based on Dr. Rosenbach's fee schedule. So that's why we think, the prepayments here, that's all in plaintiff's hands. What prepayments they want to make on costs that they may have in the future. And that's something that the defense would be disadvantaged. And it is possibly something that can lead to some gamesmanship here in the proposal for settlement world. That's why if the trial court's decision is the decision moving forward, we need direction on that, because it changes things and it changes the risk analysis and calculations that go into whether to accept or reject a proposal. Again, we think the court needs to follow the guidelines. This case can be black and white. It's not taxable. These prepayments weren't taxable costs under the guidelines. The depots haven't happened yet. No testimony was rendered at this time and didn't happen till well after. Following the guidelines, as the statute says, as we feel Justice Pariente meant by when she said a judgment is to be entered on the date of the proposal. Well, only costs that are taxable can be included in a judgment on that date. Further, the uncontradicted evidence showed that even if the court doesn't want to look at the guidelines, plaintiff was going to get her money back here, and she didn't prove otherwise. Therefore, we think the trial court got it wrong, and the guidelines need to be used, and which means that these are non-taxable and have to be taken out, which requires the reversal of the fee judgment here. And unless your honors have any questions, I would reserve the rest of my time for rebuttal.
Very good. Thank you very much. You'll have your 3 minutes for, I think you asked for 3 minutes if I didn't write it down, but that's my recollection. Is that
yes,
correct?
3 minutes. Thank you, Your Honor.
And you will have the full 3 minutes. Mr. Anderson.
Good morning, Your Honors. May it please the court, David Anderson on behalf of Gloria Washington. I would like to address just one quick thing before I get into the merits of my argument. There was some mention about these being voluntary prepayments, and I think that's important to point out because Judge Silverman, you had mentioned it, and I think it's important. It's on the evidence that was referred to in the hearing, and I'll get into the insufficiency of the evidence in a minute. But what was referred to in the hearing is at record 1609, and it's Dr. Rosenbach's invoice. And on his invoice, that is what was referred to by trial counsel for appellant. It says at the bottom of the invoice, first of all, it's an invoice for $1,400 that was actually paid on March 18th of 2019. So 3 days before the proposal for settlement was filed. It says at the bottom, $1,400 prepayment made payable to David Rosenbach, MD, PA, is due in our office by Thursday, March 21st, 2019. Thank you. So this was not a voluntary, certainly with regard to Dr. Rosenbach, this was not a voluntary.
Anderson, if you're going to rely on that document, don't we also need to take a look at the language that says 72-hour notice of cancellation is required for all appointments, otherwise payment is due and so forth. Prepayment becomes non-refundable for depositions and trial testimony if it's not done within the 72-hour period.
Yes, Your Honor, but that's a separate document. That's not this invoice. So what you're referring to is a fee schedule that was sent to my office. It was sent to a paralegal named Nicole Zutz, who was not the paralegal on the file. She was not the paralegal that filed the affidavit for costs. My firm's email that was filed with the court, the e-service email, was not attached to that. So that was not something that was in the record that was actually even received and considered by my office. So, but at the very least, assuming that the court is going to consider that, at the very least, that creates a huge ambiguity.
Did you ask the court to strike that document?
That document was never entered into evidence, Your Honor.
No,
there was no.
It was argued, correct? Both parties argued it.
It was referred to in the hearing, Your Honor, but it was not entered into evidence. I mean, if something is filed with the court, when you attend an evidentiary hearing, unless it's entered into evidence, my position is it's not evidence. It has to be marked as an exhibit. It has to be entered into evidence. This was an evidentiary hearing that was properly noticed. Everyone knew this. Mr. Wood is an experienced trial counsel. He knows how to enter evidence. He knows how to admit evidence in a hearing and at a trial. That wasn't done in this case. So there wasn't. If he had moved it into evidence, that would have given me an opportunity.
I'm assuming both parties are pretty experienced counsel, aren't they?
I would say so. I would like to think so.
Let me ask then this question: whose burden is it to establish that a cost is reasonably necessary and recoverable?
That at a trial or in the hearing? Yes, Your Honor. That would be the plaintiff's burden.
Mr. Anderson, are you going to draw a distinction in terms of whose burden it is to establish a cost based on something that happens at trial?
No, Your Honor.
Okay, so let's go back to my question. Whose burden is it?
It would be the plaintiff's burden to meet that initial burden, but I would sort of akin that to.
So let me ask then, if it's the plaintiff's burden, do you agree that first you have to establish the costs were reasonably incurred?
Yes, Your Honor.
Do you have to establish under the case law that testimony was obtained in deposition or in trial to make a deposition cost or a witness cost recoverable?
Yes, for purposes of determining if they are taxable. Yes, okay. Your Honor.
And then do you have to establish that the cost was recoverable at the time the proposal was made? Not at the end of the 30 days, but at the time the proposal was made?
No, Your Honor.
Isn't that what the case law says?
No, Your Honor. I don't believe so. So looking at the case law, the first case to look at, and I think is the seminal case on this issue, is the White versus Steak and Ale case. And so in the White versus Steak and Ale case, it's on page 551, and I'll just read from it. It's on the left-hand column. It says, thus, in calculating the judgment obtained for purposes of determining whether the party who made the offer is entitled to attorney's fees, the court must determine the total net judgment, which includes the plaintiff's taxable costs up to the date of the offer. So according to White,
don't you have to look at the uniform guidelines to determine if that's a taxable cost? Because you cannot read that in exclusion of you're only entitled to a cost if the final judgment was entered on the date of your offer. You chose to pay it early. You made that choice, and you chose the timing of your proposal for settlement. The undisputed truth here is you didn't take the depot by then. You didn't incur the cost by then. You didn't have any testimony by then. You had a prepayment that you chose to make. Do you understand what Ms. McLemore's saying? That if we change the law because plaintiff's attorneys or defense attorneys, let's talk about an IME. Let's say that they decide to prepay an IME, send an offer, they win. They going to get it? If it could have been canceled or refunded? You're making the same argument if it's on her shoes. So I don't understand this. We cannot the law can't be a moving target.
And that's exactly the point.
But you made a choice. You didn't. Your payment wasn't due on March 18th. You paid it on March 18th.
Well, I paid it on March 21st because Dr. Rosenbach said it was due by March 21st.
Okay, but it was still refundable if you had canceled it right after your offer, correct?
Right. I would do. We don't know that.
Yes or no?
No, we don't know that, Your Honor. That's
so that's not what his office says. That's not what that note says. If you canceled it on the 21st or 22nd or 23rd, you wouldn't be refunded? Is that what you're telling me?
Your Honor, what I'm telling you is I don't know. I mean, that's an impossible question to answer.
Then does that fulfill your burden? Did you prove your burden if you don't
Your Honor,
know?
Well, no, because the burden is I can't be my burden is not to disprove every negative and every theory and every argument that the defense brings up. So I would akin that to a prosecution case, like a criminal case. So if the prosecution meets its initial burden and the defense brings up a theory that they have that maybe someone else was committed the crime, it's not the prosecution's burden to prove that theory is wrong. The defense would need to bring some evidence to support that.
Mr. Anderson,
actually, it is.
I would have more. I don't know. I don't want to say sympathy. That's the wrong word, but I would be more appreciative of your argument if this had happened. One, we know under the case law, the general rule is you can't recover the fees that you're seeking unless testimony had been given. That seems to be the general rule under the case law, either testimony in deposition or testimony at trial. So in this case, we know that didn't happen. So to go to Judge Sleet's point, isn't it your burden to establish at the hearing, to sort of expand the rule to show, look, we know we didn't get the deposition taken before the offer was made. However, that money is non-refundable. Therefore, the court has some discretion to award that as being a reasonably necessary cost because, Judge, we would never be able to get on their calendar had we not prepaid it. So why is that not your burden?
At that point, if that's my burden, I'm being required to disprove a negative. And
well, I want to interrupt because I don't see it that way. I see it as you're asking for recovery of a cost that generally is not recoverable because no testimony had been granted. So don't you have to convince the trial court and this court that there should be an exception to that general rule because, Judge, this amount was non-refundable?
I mean, Your Honor, that's an analysis that we can make, but it requires you to adopt the defense's interpretation of White. So my interpretation of White and what I think is support.
I don't agree with you. And the reason I don't agree with you is something that neither party really seemed to address under the guidelines. And under the guidelines, it says the burden of proof. Under these guidelines, it's the burden of the moving party to show that all requested costs were reasonably necessary, either to defend or prosecute the case at the time the action precipitating the cost was taken. Now, you both talked about the general burden of proof, but what you didn't talk about is what is now, I think, an exception to the general rule, which is, Judge, this cost was reasonably necessary and it's not refundable, so you ought to award it because this is not part of the general rule that you have to have testimony. So I will tell you very candidly, I'm troubled by the failure of the plaintiff to establish that, in fact, this was a non-refundable cost.
The issue, but Your Honor, the problem with that analysis is we're looking back retroactively. The fact is that Dr. Sachs actually did the fact is that Dr. Rosenbach actually did testify at trial. Dr. Murphy did testify.
That was after the offer of judgment, correct?
And
so you can't use the subsequent facts to back up and say, well, as of the date of the offer, it's a recoverable cost. The testimony had not been given. And the White case and other cases make it perfectly clear that it's the date of the offer that is the controlling date, not what happens later.
Well, but that depends on the analysis, Your Honor. So what should be done is you make the determination of what the costs are taxable, and then you look at the date the proposal for settlement was filed. You draw the line in the sand, and then what costs were incurred prior to that date. And that's how you come to the net judgment. If we're going to
so
create
what under the uniform guidelines makes a prepayment of a hourly rate for a deposition or a flat fee for a deposition, what under the guidelines makes that taxable on the date of the offer being made?
Well, I mean, the guidelines don't specifically speak to that. You would need to go to the White versus Steak and Ale case, and you would need to go to
the White case and the other cases all talk about what was recoverable as a cost on the date of the proposal. And so, I mean, I will tell you, I appreciate the argument that you're making in one respect. If it were a non-refundable cost, I think I could be persuaded that there's enough discretion in the guidelines to allow the court to award it. And I don't know if my colleagues would agree with that. They might not, but I think there might be enough discretion there. So I'm going back to the idea of what proof is there that it was not refundable on the date of the offer?
Sure. I would point towards on the date of the offer, as far as it being non-refundable, I would point to the record 1609, which is Dr. Rosenbach's invoice, where he says $1,400 prepayment made payable to Dr. Rosenbach, due in the office by March 21st, 2019. I agree with you that there is that fee schedule that may or may not have been received. I agree that that is out there, but at the very least, that creates a severe ambiguity as to whether or not it's refundable. And my argument is that shouldn't be the plaintiff's burden. If that argument is going to be raised, the defense needs to bring forth evidence to support that.
So the burden of proof language in the statewide uniform guidelines, your view is, well, we met our burden by showing we paid it. It's now their burden to show it was not refundable, that it was in fact refundable.
Yes, Your Honor. We paid. It was their expert they designated. We told them we wanted to take the deposition. They sent us a bill. We paid it. Dr. said it's due by March 21st, 2019, which is the date the proposal for settlement was filed. And I think, something else is important to discuss, and that's the standard of review. What's the review for this case? And there's, obviously three things. It could be abuse of discretion question, but this was an issue.
Can you hear me? You froze there for
yes, I can.
10 seconds. So I think we got the gist of what you were saying, but if there's anything you want to emphasize, you froze up for about 10 seconds there.
Yes, Your Honor. So the first question is what's the standard of review? This was an evidentiary hearing where evidence was presented, at least plaintiffs presented evidence, testimony was taken. At the very least, this should be an abuse of discretion standard. What did the court abuse its discretion in holding that they were pre-offer costs? And as cited in my brief under Eagle Crest LLC, to find that the court abused its discretion, this court must find that the trial court acted arbitrarily, fancifully, or unreasonably. And I don't believe that's the case. The second part would be the procedural argument. I think we've touched on it. There was insufficient evidence to establish their theory, their argument that it was actually refunded. The next issue would be how to interpret White. And I think we've talked a little bit about that. I read that portion of White. I'd also rely on Hastings versus Skipper Day, which cites the White and says that the trial court in White concluded that a judgment obtained pursuant to Section 76879 includes the plaintiff's taxable costs up to the date of the offer. And just one other thing to kind of supplement that, as to giving the court some direction as to how to calculate these pre-offer costs, would be the Bullis versus Florida Department of Transportation case. And I understand that was an award of prejudgment interest, but it's important in that case where the court says that you determine prejudgment interest based on when that cost was paid. And so if you follow that logic, and when is the cost paid, That's when it's a pre-offer cost. That's when interest is calculated to. There's no question. There's no issue. There's no gray area or exception that needs to be established. It's clear and the parties can understand it and follow it. So I think that's the more concrete and that's the more reliable analysis to make with regard to this issue. And with that, unless the court has any more questions, I'll rely on my brief.
Very good. Thank you, Mr. Anderson. Ms. McLemore, you have your 3 minutes of rebuttal time.
Thank you, Your Honor. Quickly, there are four points I want to address real quick from Appley's argument. First, our evidence wasn't a theory of refundability. It wasn't a theory. It wasn't an assertion. We presented evidence that the prima facie evidence that these fees, these prepayments would have been refundable. At that time, plaintiff had every opportunity to present evidence that they would not be refundable. That evidence isn't something that's impossible to gather. They could have gotten the doctors there. They could have presented a fee schedule or whatnot, but they didn't. Whether it exists or not, I don't know. We presented the prima facie evidence of refundability. Second, as to plaintiff's argument that defense failed to enter evidence into the hearing, this is an evidentiary hearing, again, where plaintiff has the burden. If we're talking about our requirement is to enter evidence at the hearing, then the judgment is required to be reversed because plaintiff didn't enter any of his evidence, her evidence into documents into evidence. Further,
they had a witness testify. I mean, I think the question, I'm assuming what you're pointing out or trying to point out is they didn't present evidence as to refundability or non-refundability, because clearly they put in evidence. Your side didn't put in any evidence other than cross-examining witnesses, right?
Yeah, they presented evidence of the reasonable amount of the cost. And that's what the court limited their expert testimony to, is reasonableness of amount. But they didn't present any evidence on refundability or this issue that on these prepayments that we're talking about. We filed this evidence in advance. The court, we talked about it at the hearing, and the court put this in the order. So the court considered this evidence before. And then further, as to just really quickly on their argument that they didn't receive this.
Hang on, let me ask one more question about that, because I have a recollection, I think I have a recollection that there was some statement by plaintiff's counsel that it was not certain that they had received the fee schedule from Dr. Rosenbach. Did the trial court accept that as testimony, reject it? Was it offered as testimony, or was it just argument?
Your Honor, Your Honor, I don't believe that was even argued below that they didn't receive it, because on the fee schedule issue, they never even talked about it. We said that we filed this evidence, it would be refundable. And in response, I believe all that they said was maybe it would have been refundable, who knows? That response was, like I said, record site 1758. However, as to that argument, even if they did bring it up at the hearing, because I'm sorry, I cannot remember exactly, but even if they did bring it up at the hearing, it's an irrelevant argument. First, those exact same individuals that they're complaining about aren't working for their office or it's the wrong people were the exact same individuals that received the Dr. Murphy invoice, the other prepayment. And that was undisputedly received, paid, and they've included in their costs. So it's a little odd for them to argue that these people aren't those people when those same people, nobody else was served with the Dr. Murphy invoice. And further, again, we argued this in our brief. It's plaintiff's burden when they serve a proposal to include all the proper taxable costs in that proposal. It is their burden at the end of the case to prove all their pre-offer taxable costs. Whether they knew what their...
You've got about 10 seconds to wrap up.
Okay. It is their burden to prove that, whether they knew it or how they calculated or not before. Your Honor, we would ask that this court follow the guidelines and that require that follow the guidelines on taxable costs. These costs would not be considered taxable. Therefore, they should be taken out of the judgment obtained. Plaintiff would not trigger her proposal for settlement, which requires a reversal of the fee judgment here.
Very good. Thank you, Mr. Anderson and Ms. McLemore. You need to click the leave button, and then you can stay on and watch the streaming if you so desire.
Thank you, Your Honors.
For planning purposes, the next case